Number 2 and 3, matter of Kelly versus DiNapoli, matter of Sica versus DiNapoli. Thank you.
May it please the court, my name is Joseph Doherty. I'm representing James Kelly. I'd like to reserve 1 minute for rebuttal.
You may, Mr. Doherty.
Your Honors, this case is very simple for Mr. Kelly.
Counsel, what's the accident? From your client's perspective, what is the actual accident?
The accident was my client protecting his partner as a rafter fell towards his partner.
Is part of the equation that the accident has to be not foreseeable?
Exactly.
And going into a collapsing building, while obviously laudable and commendable on the part of the police officer, is that something that's not anticipated or foreseeable?
Well, I think there's two issues there. The first issue is my client testified at the hearing with the hearing officer who found that my client was entitled to ADR, that the building was stable when he went in. That was uncontroverted. As he was in the building attempting to rescue the family, that is when the rafter fell and he put his hand up in order, neck and back injury, in order to protect his partner.
Isn't it a different question? Let's go with what you're saying. But when it goes in, it's stable. It isn't the question of whether it's foreseeable, that stability is momentary given the nature of an ongoing storm and the condition of the building when he goes in?
I would agree with that, but at the same time, I would say if he's going into the building, in 19 years, he had never been asked to do anything like this. It was not foreseeable that a rafter would fall while he was in the building.
It seems to me most of our cases on this subject talk about an unexpected event, and the conversation that I'm hearing, and that certainly has been in some of the briefs, has been about foreseeability. Is there a difference between unexpected and unforeseeable?
I think there has to be. If you look at a lot of the case law that provides a foundation for cases like this, a police officer that sits in a chair at his office and one of the screws falls out. The chair falls, he hurts his back, he gets accidental disability. I think that the case law has evolved to a point where you look at a job description and you say that you're going to respond to an emergency, and everything in that emergency is then foreseeable. There has to be a place where there is unforeseeability within a certain emergency, and that is this case.
Well, but if I guess my question is was it unexpected, and could there be other things that were a part of this scenario, such as the fact that it would be unexpected that the normal responders who would actually go into the house could not make it there in time? Could that have been an unexpected event that would be accidental?
Yes, and I think that was a predicate to my client having to go into the building. Is normally, if there was not a hurricane, the firefighters, the EMS, might have gotten there in time in order to go in and do their job, which is normally their job, to try to rescue people that are in such a building.
What about the argument that that this was a voluntary act? Mr. Sica seems to distinguish his case from yours on something along those lines. How do you respond to that?
Well, I think, number one, I think the comptroller respondent in my matter, has conceded that point. I don't think that was briefed. But at the same time, my client was required to protect and serve. And in situations where the fire department, the EMS, could not make it in time, my client was responsible for going in. Now, when my client was in the building, if he's just pulling rafters, if he's pulling debris, that's one thing. That could be foreseeable. That could be expected. If you're running into a building, you know there's damage. You know you're trying to rescue. Pulling debris is definitely something that is expected.
Well,
a rafter falling is not expected.
You see, here's the thing. It seems that we're talking about risks that are inherent in regular employment duties versus risks that occur during the course of regular employment duties. That's the distinction that seem to be drawn. So it's fair to say that a firefighter goes to a scene where property is being damaged, and it's always a risk inherent in the regular employment duties that part of that building during a fire may fall on somebody who's a firefighter. But it's not part of the risk of a police officer and the risk of their regular employment duties to do that. So the question then becomes, I think that's an easy enough distinction to draw. The question then becomes, though, is are the employment duties written so broadly to cover anything that occurs in terms of public safety in the context of a police officer's duty? And if so, then almost nothing would be an accident and everything would be covered by regular disability, or the opposite, everything would be an accident covered by regular disability. And I guess what I search for is the rule on where to draw that line. That's what I'd ask you to point us towards, or say we.
Yes, I mean, I think that is a fantastic question, as far as you don't want to open the floodgates for ADR.
Yeah, so where's the line here?
And I think the line is there. And in this specific case, the line is definitely present, where a hearing officer heard testimony. The hearing officer heard testimony that in 19 years, my client was never asked to do or required to do what he did that day. The hearing officer determined that it was unforeseeable. The hearing officer determined that my client was entitled to accidental disability. The comptroller overruled the hearing officer simply by looking at that broad job description. This case is not one that will open the floodgates for ADR.
And is that because of the nature of the risk? In other words, the injury occurred during a hurricane. It's different from, say, a pothole or a wet floor, which happens more ordinarily in the course of the duties. Why do you say it's different?
I believe it's different because of the circumstances surrounding what my client did. As I said before, if my client ran into the building and was just pulling debris and hurt himself, that would be one thing. But running into the building, pulling debris, and then in the course of pulling debris, having a rafter fall to protect his partner, putting his arm out to deflect that debris, caused the injury. There has to be a line whereby, even if you're responding to an emergency, that there can be within that emergency some form of accident. And I think the hearing officer got it correct. And I think that this court, in your previous decision in Yoga Vida, was on point as far as looking at the record in its totality. Substantial evidence does not support the comptroller overruling the hearing officer.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. William Storrs for the respondent. Police and firefighters have dangerous jobs. They know that going in, we know that, and we're grateful to them.
But under your, as I understand your proposed rule, essentially there would never be an accident.
Absolutely not true, Your Honor.
When would there be an accident?
Well, for example.
Tell me what the rule is.
For example, it's something that is not a risk inherent in the job. For instance, if he'd been driving there, his steering had broken, his brakes had gone, his equipment broke, if he'd been using a tool, if that tool broke.
How do we define the job? In other words, in this case, Mr. Kelly said it was not my job to go into this building. My job was to secure the perimeter, make sure nobody goes into the building, and wait for the firefighters and other people. Okay, but I couldn't do that. And that was unexpected.
If there were other people there, but his underlying job description, the written job description, said that his job was to respond to calls in his assigned area and to assist any injured person. And even then, the instructions that he received on the day of the hurricane were to shelter in place and not to respond except in life-threatening situations.
So how should the court factor in the lack of training to deal with the particular emergency?
The lack of training, I don't know exactly what training would have been necessary to go in and remove these things.
I'm having trouble with the example you gave to Judge Stein, that if he was driving and his car broke down or his equipment failed, I mean, those things happen in the real world.
But they are not considered to be risks that are inherent in the job.
Why not?
The controller has found...
Wait, isn't the risk in my driving my car that the tire is going to blow out?
That may be, but it is not considered to be a risk inherent in the job of a police officer, as the controller has construed the retirement law.
But isn't it part of the police officer's job to drive in his patrol car to the location of the emergency?
For instance, I believe in that the expectation is that he would have a car that did not break down. Having a car that breaks down, having a tool that breaks in your hand, those are things that the controller has found that are.
Is your point it's no greater risk than it is for anybody else
That's
behind
right.
the wheel of a car?
It's not particular
so
to that.
It's not particular to the job.
It's not particular to that
Okay,
job.
so let's go back to the training. It seems to me that this is a compelling argument. You're asking the individual to run into a building who doesn't have training to assess the risk or to assess how to address the risk once they're in the midst of that environment.
He assessed the risk correctly. It was a very dangerous thing to do. He went in, they looked, and contrary to what he says about them, not about the building being stable, he said at page 189 of the record that the building appeared to be very unstable when he went in.
Well, someone had already died there, hadn't they?
Someone had already died, and he was aware of it.
There were two other people that he pulled out, right?
Yes, that's correct.
When he ran in, did he know someone was dead?
Yes, he did know. He had already been told, I believe, in the
know
phone
how?
call. I believe the tree falling and the house collapsing.
It was obvious and visible when he went in?
Extremely obvious and visible. They said that half of the roof was gone, part of the roof was still dangling. It was shattered.
Isn't also
So
proper
we're back
training?
to whether or not it's an occupational hazard or a hazard that's not inherent to the occupation itself. Is that the distinction you would draw?
Well, what the third department put it best. They said the threat that compelled the response was the threat that caused the injury. He responded to the threat of collapsing building, and the building continued to collapse on him as he was working to extricate the people.
I'm sorry, what's the accident?
So that is then an occupational hazard to being a police officer?
Yes.
So what's the accident? He told us what he says is the accident. Do you agree?
No, there is no
Okay.
accident. This
I'm
was,
sorry, when-
and because there was not an accident, petitioner qualified for a benefit that other people don't get. He qualified for performance of duty. It's important to recognize that back in the 1980s, the police and the fire complained to the legislature. They said accidental is too hard to get. It's leaving people uncompensated. The response of the legislature was not to expand accidental. It was to create an entirely new level of benefits.
I wasn't clear before. In his position, or an officer in this position who runs into a house to try and save someone, you've already given the other example, the drive on the way. So is the controller's position, once you run into that house, anything that happens to you is not an accident? Is there anything that could be an accident when you run into that house?
I don't know that if I can address quite that broad a hypothetical. I think everything depends upon the facts that you are given, that you have to deal
Well,
with.
let's say he trips on a wire while he's running into the house, because they had a space heater plugged in.
Probably not. Probably
Is that,
not.
because it's not related to the danger?
Yeah, we have the case, well, because the danger is in a house that is collapsing, things are going to be
Collapsing
a
of the
mess
house.
around you. We have the Lassen case where a firefighter was backing out of a burning building and he tripped over objects on the front porch that he could not see.
But see, let's take a step back. Those are ordinary hazards of life. Stepping into potholes, stepping on wet floors. And there are cases where accidental disability pensions have been given potholes, ice in specific situations,
Yes.
yet nonetheless they've had it. See, it's the consistency of the rule that I struggle with legally in fairness to the employees. And that's where I'm having a hard time drawing the line. And so we don't only have the distinction between an occupational hazard and a risk that is not inherent to the activity, but we also have a distinction between those hazards that arise and the ordinary hazards of life that one encounters while doing your job.
Yes.
And an accident. These things are all, in common parlance, considered an accident. So once again, we're back to what's the rule besides saying foreseeability that would tell us where we should be looking to draw this line between the two? What would you suggest to us?
The rule is whether it is a risk that is inherent in the duties and the response, or whether it is that proverbial bolt.
So is there a distinction to a first responder of any kind between who's responding to emergencies? Does that mean that anything that happens in the context of that occasion, whether it's a hurricane, whether someone's trying to break into a building, whether you're chasing somebody through an alleyway, whatever it is, if you're acting with your police uniform on, it cannot be covered by accidental disability
No,
insurance?
that is not true.
Okay, so what's the rule for us then?
It's any risk that is inherent in the duty that you are performing. But if it's something that happens that is extraneous to that,
Give me an example.
well, as I said before, there are examples where police officers have been using tools to try to extricate people, police or firefighters, and the tool breaks in their hands and disables them. That is not considered to be a risk of the job, inherent in the job. That is considered to be an accident.
What weight do we ascribe to the fact that, under these circumstances, the police officers were, as I read the record, the only first responders on the scene?
Well, I think that what it does is just reinforce the underlying duties in the job description. As he said, I did what I did because no one else was there to do it. It was his job to rescue and assist injured persons, and he performed that job admirably. And it's because he performed that, it was injured in the process of doing that, as a result of a risk that was inherent to it, that he received the benefit of performance of duty.
Thank
So
you.
it's a risk inherent to his job description, what he's doing in the moment, and the nature of the emergency itself?
That's correct.
Thank you, counsel.
Thank you.
Counsel?
Your Honors, I would just like to point out one standard, which is substantial evidence. You just heard from the comptroller that there are situations where you respond to an emergency and you can receive accidental disability benefits. In this situation, my client testified to the hearing officer about the emergency. The hearing officer, hearing all the facts, all the testimony, which was uncontroverted, rendered a decision that my client should receive accidental disability benefits. The comptroller overruled that determination simply by looking at the job description. Therefore, the comptroller's determination was not supported by substantial evidence.
Thank you, counsel. Appeal number 3, the matter of Sica versus DiNapoli.
I think I got to switch sides.
We got to switch sides, Bill?
I got to switch sides. All right. I don't know where you have to go. No, I listen over to you now, I think.
Do I have to go back to
I don't know.
the gallery?
I don't know. It's good to see you, too. Take care.
Pleasure.
I hope I did that right.
Correct.
All right,
Please
thank
proceed.
Your Honors, as in Kelly, the very threat that compelled the response is the threat that caused the injury here. Petitioner, a firefighter, responded to a call for difficulty breathing, and after treating the people, he himself
But what in
suffered
that
from the
phone
difficulty
call
breathing.
would have alerted the firefighter that there are toxic fumes?
I think, again, Your Honor, the problem, and this is the problem in the Third Department's case, is they focused on the individual's awareness of the risk as opposed to the analysis of the risk that is inherent in the duties. There have been many, many, many cases where the courts have found that there was no
But usually
accident.
responding to, someone's having difficulty breathing in a store, does that automatically carry with it an inherent risk that there are toxic fumes in the store when everybody else, when you run in, seems to be fine?
Well, no, I think that the way to look at it is not that, but although it's true that when he got there, he found 2 people down suffering respiratory difficulties with nothing else apparently wrong. Is that, in effect, a clue that there may be a
And
problem?
a lot of other people who were upset but
not.
seemed to be breathing. They were
Seemed to be breathing, but
standing,
we're
they were
not, but
speaking
we're
to
not
him.
in, I didn't mean to interrupt you,
sorry.
but not in that small enclosed area. But here, the problem is the focus on the individual awareness of the hazard rather than on the risks inherent in the job. Petitioner's job duties, again, said that the work of a firefighter is of a hazardous nature. His job was to administer first aid as a firefighter.
So then is the expectation he would have run in, having received this call, to run in with the whole mask, all of the apparatus?
Or if necessary, to get it when he realized that there were two people down with breathing difficulty, who were unconscious. Yes. There was nothing in the record to show that he could not have done that had he chosen.
What effect does the Hart presumption, not to knock you off too much, but clarify that in my own mind for me?
Well, the Hart presumption really doesn't have any applicability here. He got the Hart presumption under the performance of duty benefits. But it wasn't even addressed as to whether it would, before you would have reached that.
So it affects the performance of duty benefits, but not the accidental disability pension?
Not yet. If it had been determined that this was an accident, then there would have to be further findings of causation on that. But those weren't done below, so it's really not part of this
Well,
case.
what if we reverse this case? Does that have to be addressed?
Yes,
The
it
Hart
will have to
presumption?
go back to the controller
Okay.
for further
I see.
proceedings.
So it would go back because there was proof in the record on the Hart presumption. I thought the state had put on an expert. And
There was proof, but it wasn't specific to this instance. Petitioners suffered from 3 separate instances, I believe, where there were toxic fumes.
But there
And
were 3
wa-
other besides this.
2 other beside this.
2 other? Okay,
I think
3
2
total.
other.
Okay.
But there wasn't any specific causation, and those were conceded not to be accidents, I believe. There was no specific medical evidence tying the causation to this incident as opposed to the other 2. So I think that it would have to go, if this court confirmed that it was an accident, it would have to go back.
Did the controller rely on the foreseeability of this toxic fumes in the controller's
Not so much,
decision?
because again, I say the individual foreseeability leads you the wrong path in the analysis. It was the third department's errors in this case in analysis were focusing on the individual's awareness rather than an analysis, as this court has said, of the job itself and the risks that are inherent in that
All right,
job.
so how would you reword the standard that's in McCambridge and in our cases so that we can get some more uniform approach out of the third department?
Well,
and I'm assuming that we're only talking about this 3-tiered system, and this has no applicability for what goes on in the city, where there's only a 2-tier system.
That's right, and by the way, I do need to apologize to the court, I almost forgot. There is, we mistakenly referred to the court officer's Cowell case as involving performance of duty in our brief. It does not. What we would suggest, the primary problem here appears to have been in the distinction between ordinary and not ordinary duties, that construction, which comes out of Liechtenstein, the use of the word ordinary. I would suggest that word ordinary should be struck. It's not found in the statute. It should be simply an analysis of what the duties are, not ordinary versus irregularly occurring or anything like that.
So, and I forget which one, one of the petitioners here claimed that the duties had to be routine.
That's right.
That's what you're seeking to eliminate.
Yes, the 363 doesn't say that. And what's interesting also is that there's a parallel construction between the accidental in 363 and 363C, the performance of duty. If you put a regular duty requirement in the one, you're putting it in the other. That's going to be very problematic for people getting performance of duty if they're told this was a rarely performed duty, so you don't get this benefit.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. May it please the court, my name is Donald Henry PC, representing the respondent, Yonkers firefighter Pat Sica. Judges, let me just start by saying what you heard from the controller is a superhuman definition of accident. This court said in 1982 in Liechtenstein, and again in 1984 in McCambridge v. McGuire, that the intent of the legislature was to apply an ordinary definition of accident. To apply anything other than an ordinary definition of accident is going to basically remove accidental disability from first responders. This is the position the controller has historically taken. Judge, when first responders are performing ordinary duties, unexpected events do happen. And unexpected events, I agree with you, Judge, are basically unforeseeable. And that is what happened here. Firefighter Sica.
Well, can I just probe you
Sure.
a little bit on that? Because we got away from it earlier. But it seems to me that an event can be foreseeable but still unexpected. I don't see the two as necessarily coextensive.
Well, I think that what we are talking about first responders. Firefighters are on notice of ordinary hazards. They train for ordinary hazards, okay? That's why many of the things that happen on a fire
Is exposure to a toxic gas an ordinary hazard of the job?
This is a context thing, and that's why what this court said, going back to Liechtenstein, is, again, it's a case-by-case basis. Context matters. The problem with what the controller wants to do, he wants to paint a broad brush, which I'm saying is just, excludes so much. First responders.
No, we understand that, but going back to Judge DiFiore's question is, in the context of responding to a medical emergency, you wouldn't think there'd be a chemical leak. That's the core of your argument. Now, let's take the other side of that. The other side of that, though, wouldn't that create a number of inconsistencies in our own jurisprudence and in Third Department jurisprudence in the kind of cases where you would have what appear to be serious accidents that wouldn't qualify? I shouldn't say serious, because these are actually all quite serious, but a certain type of accident that wouldn't qualify in the context of responding to a non-medical emergency. And, for instance, you respond to a chemical leak, you get injured, you're not entitled to accidental disability insurance. The injury could be much, much worse. Right. Yet at the same time here, you're responding to a medical emergency, a relatively, in the scheme of things, a firefighter could do that 3 or 4 times a day, right? Easy. Right. So you're doing that, and it's a relatively minor accident in that scheme of things. Yet you get a 75% disability pension as opposed to, say, if you got 20 years in, 66%. Well, Judge, you see the problem,
right? But
in terms of our jurisprudence.
But what the controller supports is a first responder gets his pinky caught in his tool, he gets a 75% pension, and then the brave 2 cases you have before you where the first responders are risking life and limb, they don't get it.
But isn't that a function of the statute? I mean, that's the problem here, right? Because in your hypothetical, they would get a higher recovery under a disability than somebody who runs into a building and is injured rescuing a child. And that argument really goes to the statutory scheme, though.
But what we're asking, and I think that what this court has supported since 1982, is a fair case-by-case analysis, looking at what the ordinary risks are, and looking at factors as whether it was reasonable for the first responder not to foresee the hazard.
And wasn't that done here, and it was found not to be an accident at some point, right, in that lower level?
The hearing officer found it to be an accident, and I'm the respondent. The Third Department majority found it to be.
But the controller found it was not.
The controller found it was not criticizing the foreseeability angle at all. This is not a foreseeability case. Both the hearing officer and the Third Department found, as a matter of fact, that firefighter Sica, it was reasonable for him not to foresee the hazard. The controller superseded the hearing officer on the basis of the job description, dangerous job. And if I may just say one more thing, if you look at the record at pages 103, 104, there is the civil service job description. The civil service job description is written by the employer. And if you look at that, if you look at the second paragraph of the second page where it talks about environmental conditions, it says that when you're doing emergency medical work, the hazard is risks of exposure to disease and upset people. That's what it says. It doesn't say poisonous gas.
Well, I thought that controllers, maybe I misunderstood him, I'll ask him when he gets up. I thought his position was that once the firefighter ran into the market and observed the circumstances, at that point, should have realized, no, this is not just someone who's got shortness of breath. There may be something external here, and I should be taking precautions. And that's where he failed to do that.
I agree that's a very important point. But what I'm saying is that the third department majority, when they looked at the record, found as a matter of fact that the controller did not supersede on that basis. So that if you stick to this record, you can find that it was not foreseeable, because that's a foreseeability thing. The foreseeability angle was added by the dissent down below. It isn't really in the record. And one final point that goes with that. When
The record doesn't support that conclusion by the controller.
Correct.
Okay.
One final point is firefighter Sica was one of 4 people that went to that market. When he got off that fire truck, he had a lieutenant. The lieutenant is responsible for his safety. That lieutenant said, don't take your firefighting gear. And I don't mean in so much words, but they thought they were on a medical call. And he was responsible, if anybody was, to pick up something different and to make that change, to go get masks or to go get more protective equipment. He never did that because he never recognized the hazard.
Thank you, Mr. Henry. Counsel, do you care to exercise rebuttal?
Very briefly, Your
Yeah.
Honors. First of all, what he just said about the lieutenant is not in the record. Secondly, the primary analysis by the Controller's Office was on the basis of the job description and the risks inherent. The matters cited by the dissent in the Third Department are certainly supported by the record, though. There was certainly reason for him to have anticipated the hazard once he was on site. But the ultimate thing was that he was there as a firefighter. He was quite particular about that. During the examination, there was some questions about, were you there as an EMT? He said, no, I'm a firefighter. So these were the job risks of a firefighter, not the job risks of an EMS person. And as your respondent said, yes, the problem here, if there is one in the statutory structure. Would it be possible for the legislature to create a benefit, a special benefit for people who were injured in the course of duty during an emergency response? Of course they could. They've done things like that, for instance, with the World Trade Center response. They created special presumptions for them. They have even in some cases, such as the O'Brien case that I had here, which never got to be argued, to pass a special law benefiting a particular individual. But those things were not done in this case. Thank you, Your Honors.
Thank you, Counsel. Thank you.